that husband of yours? He's still doing it?
Oh, really?
Okay, that's what he said he's doing. I don't keep up with it. I don't know who's doing what these days apart. He probably likes that other better.
That's better. Hi. You're good to go, sir.
Thank you very
And
much.
when you need to toggle, I can tell you something.
Sheila, you want a tea?
Great.
Yeah,
You gonna be hanging out?
yeah, I'll be here.
Thank you.
Okay, I'm still gonna get you some change.
They did say they trick-or-treated inside our house. The weather was so bad. It's poured in Lumberton. I mean,
Melissa and Alyssa, y'all are paid, right? That was at 20?
Yeah.
Right? We're good?
And I wrote my 0 out the side. I remember.
Yeah.
We just trick-or-treated in our house. And we're like, here,
That's fine.
here, baby, have a Reese's cup. Which they love Reese's cups.
What you doing?
I didn't want to be in the way, and you know, so I had it's bad.
I had to turn around and go the other way, and the dog's right. And I'm so thankful that she was open, even though she didn't have power, because there are workers in the house today, and I can't do that.
Around there.
That was where they would put all those crazy decorations on the roof and stuff. Oh gosh.
I'm just gonna sit around everything.
It was very mysterious. The guy who owned the house. Nothing really scary about you are.
Yes, Cassie.
Do you want anything to eat? My hand was really cold. I'm sorry. That was really hot. We were in the back watching.
You are good.
The dogs were just over
I think Mr.
Bella did. Must help her. I mean, it was just one. When I got home, he had everything off. I was like, that's neat. Just try to get rid of it. I don't want it. He didn't need it. So I gave him 3 handfuls. Like,
I just turned the lights off. And all day, I've been in my neighborhood. Maybe
Congrats on what you've done.
Okay, good.
maybe one.
I think so.
So I'll plan on starting the class at 12:10 and we'll end up at 1 o'clock.
That'll work.
Thereabouts, okay? Is that okay with y'all? Get a little bit of time to eat and then more people will probably be showing up too. Is that good?
That'll work.
But we'll have you out here at 1 unless y'all want to just keep talking.
How are you? Good.
Here comes, you just gonna let it go.
You know,
We got 3 extra officers in a room. I can't believe it. Cheap for good education.
well, we're gonna dedicate a lot of the time for question and answer. And we have a presentation, but we're gonna block off some just for Q&A.
That's awesome.
What's up, Andrew?
Okay, so,
Good. Now, thank you. Hey, pull off something magical. Tell Randy
Did you
she's
still
okay.
need to-
Yes, I'm gonna sign it. I'll get it. I'll get it.
right here?
No, that's the,
Oh, okay.
Oh, that's not.
Said that it's 6 centimeters or higher. She's waiting on your office.
I'm used to ask you a lot of very similar
It's the same. I think I'm gonna have to. Huh?
Hey, we
Yeah,
have
I
to
got
job.
Wow, I thought it was one of those things that, you know, it's not broke, don't fix it, it'll just go away.
I'm gonna take her out right now.
And,
I already got the ring.
Now a lot of strength in there, you want to turn it, like backward.
Oh.
Okay. It feels like it's broke. Somebody's broke. They had a dollar?
You know, that building that was the vacuum place by Tijuana,
It's right there.
they're gonna open there. Or not yet. I think they're down on Broadway or something.
So I thought I had a leg in there. And I don't know if she's still around.
Angie, yeah, she is. She had something on Facebook like weeks ago. Went to just go look at a Halloween shirt, you know, and I was like, oh, right in there. Yeah, yes, I did.
Razor on the hand like this. Well, I had a about 6 hours. So maybe I could have done something. I had another lady come to closing that was therapy. She said, it's not supposed to look like that. You have to go to the next room.
Yeah, I just wanna make sure everybody's there. There's so
I
much.
think we have plenty.
Yeah. Okay, cool. I'll make sure you get a copy of mine too.
Okay, every time, yeah. I have a high pain tolerance, unlike my sister, but I wouldn't want to have to.
You're not Christian.
I do.
It's been years, but that's the most thing I've ever been.
That's what she said. The doctor said she was.
But that crazy, he's trying to make it viral.
Textbook.
You know, I said,
He said I could tell by the way your body was positioned and pain when you walked, when you came in here. He said, I knew exactly what was wrong.
Bradley, how he does it.
That's what my doctor said too. Or he-
So it's
It's just faster, you get hospital. No, he does. Fast, but I was ready. Yeah.
They can't give me anything.
Does she live here?
Houston, Carolina.
Well, I don't even know if she has that.
Stick with that.
Wasn't it nothing but wrong?
All right.
What? That Tuesday transaction. I'm sure you probably had worse, but I had my own. And it was that was my cousin. So, I don't know if all their family after that. That's what I told my family. I was like, strict guidelines.
It was very mild.
Well,
I've had way worse.
mine was, my side of it was something else. But it was a good learning experience. So.
There's so much food.
All right, Sheila. Just passing out here. It's one of these. All right, Cass, grab a stack. You have to open video.
You can make it.
Yes, she went to the bathroom.
Hey, skip whatever.
Coming back around. There you go. There you go.
Hi, Andy, are you teaching this?
We did it.
You ought to know probate. We don't know it, don't we?
Oh, man.
After that one we had.
You know, I'm still dealing with stuff.
Thank you.
I'm just like, I don't know.
I don't mind.
So it's one of those.
But it's close.
Would you give one to Devin?
That's right.
I may as well take one of these things. It's just stating what all you do.
I'm just listening, I guess.
All right.
It's good.
And then we also have one that
You're welcome. Today's G Day. Hey, Lisa.
For gums or teeth? Gums or teeth?
So Addison was the excellent cheerleader. And Tim was the excellent player. And Aaron had a which is pretty accurate. They were
Oh,
I'm a slacker. I took the one I was supposed to go.
Just do that.
I was like, hey, let's go.
No problem. We'll get it.
He has mad size hair. And then that's after the baby. She had a little. So we just stayed inside. I had to line up buckets, probably buckets to play with, and that was it.
Oh, you do. Say hi. Monitor this.
Do it.
Yeah.
All right, everybody, let's start getting settled in. We'll get started here shortly. And everybody have their materials. You should have 3 handouts.
Do you have any pens?
We have pens? Yes, I've got a pen for you.
I think it's in.
I gotta finish part. Then you have this one.
How many? Really showing.
Got it?
Here, Andy, I got it.
Pretty good. I'm not allowed to use
MC
MC.
thing,
You
Andy.
can use whatever you want, but
Andy, where's the MC thing?
It is right there.
Oh, okay, now come around. Here, Joe, you do this. It had to come around. Buddy.
All right, okay, who needs a pen? You got two
Oh, I
pens?
need some time.
Anyone else need a pen?
I really want to get on this.
Go get my
Oh, I
phone.
gotta have mine. I turned the lights on.
You weren't asking for it.
I didn't.
I never had
And then she needs one.
Anyone?
You needed a, Joe, did you need a pen?
I got pen, I'm sorry, and I'm gonna pass this stuff out. And he gave me one after you walked out.
Okay, well, there's some if anybody.
Okay, are we ready?
Does anybody else need a pen? Real good?
All right, we're going to go ahead and get started. Thank you all for being here today for our class on probate issues and real estate transaction. Now, I know none of y'all have probably ever had an issue with probate issues, right? Now, this is a really good topic, and it's really at the heart of what we do at the title company to help get these deals across the finish line, because you end up having a lot of issues after you go under contract that you had no idea about. You know, so you do all that hard work. You either list the property and find a buyer, or you find a house for your buyer. You're like, yay, yay, yay. And then you still have to deal with inspections and sometimes title issues like this. So it catches you by surprise. So it's a really good subject to talk about, and just a whole host of issues that can come up. Let me just introduce our team that's here today, and I'll let y'all introduce yourselves as well, everyone. So I'm Andy Hemmings.
Sheila Corley. Lisa Matthews.
That's Miss Sparks.
All right, so,
I'm Kristen Fuller.
and Kristen Fuller. Oh my gosh. Oh, that's it.
Yeah.
That's horrible. Bad. Kristen. Sorry about that. Okay. So we appreciate y'all being here. We appreciate y'all using Stewart Title. I know we've all closed the transaction, so we appreciate your business very much, and thanks for being here. We're going to dedicate the first part of the class to going through these slides, and I'll just tell you right now, some of the information on these slides we're not going to spend a lot of time on just because it's just not commonly relevant to your day-to-day business. We want to leave a lot of time towards the end of the class, or middle to the end of the class, for questions from you guys, because I know y'all have lots of questions. So that's how we're going to do it, all right? So here we go. First of all, let's talk about that keyboard. Is not hooked to that, by the way. Let's try this one. All right, so some vocabulary, some of what we're going to be covering today. Testate versus intestate succession, probate, community versus separate property, independent versus dependent administrations, and then monument of title and foreign wills. We probably won't spend a whole lot of time on that. But those other topics, that's what we're going to spend a lot of time on.
Andy, do you want me to navigate for you?
No,
You sure?
I think I'm all right.
Okay.
Thank you, though.
You're
God,
welcome.
I've never had that luxury. I'm not used to that. I don't know what to do with myself. All right. No, we're good. All right, all right. So why probate a will? Why is it important that we probate a will? Anyone out there, and I know we got some topics up there, but just from what you've seen in your day-to-day business, why is it important that a will is probated?
So you can close.
So you can close. That's a good answer from a real estate agent. That's all you really care. We just want to close. You know, we don't want to know all that other stuff. That's true to help you close. Okay, very good. All right. So when the will is probated, it gives effect to give effect to the wishes of the person who wrote the will. So once, the person who wrote you got a will, but until it's probated with the court, it can't actually carry out the wishes of what the person who wrote that will is. It's also to gather the assets of the state, to satisfy any creditors from the decedent, and to distribute the remainder of the estate among the devisees. Not sure how to pronounce that. Okay. So does a will have to be probated in order for a transaction to close, though? No, you don't think so? Why not?
I think in some instances, it doesn't have to happen.
Okay.
I don't know why not.
Okay, good. Anyone else? Does a will have to be probated in order for us to close? So someone writes a will, it's not probated. Are there other alternatives?
Yeah.
What's the other alternative?
I've closed it before when they did affidavit of bearship.
Affidavit of bearship. You get the gold star, Dolores. Good job. Yay! And you get a gold star too, Joe. All right. So we're going to be talking a lot about affidavits of bearship. So even though there's a will, it does not necessarily have to be probated. Kids have to all get along. That's right. That's right. That's right. And then Lisa, Sheila, anything to add on this right here? Okay. I told them I'm gonna be leaning on them heavy. They've been doing this a lot longer than me, and they got lots more horror stories. So if you got something to add, please do. All right. Okay. The application of intestate laws will come into play if a person dies without a will, or a person dies with a will, but it has not been probated, and more than 4 years have passed since the decedent's death. So intestate laws means they've died, they've passed away, and there's no will that's been probated to carry out the wishes of their will. Okay, so you can die testate, with the will probated, or intestate. Okay, anything on that? All right. There's the steps to probating the will. The person has to file the application, then you get an order admitting the will, get your letters testamentary, and then they do an inventory and appraisal. All this stuff happens in the background. Y'all are normally not involved in this at all, but just kind of for some background information, that's the different steps. There are some different types of wills: independent, dependent, monument of title, and foreign wills. Now, Sheila and Lisa, correct me if I'm wrong, but most of the time what we deal with is going to be the independent administration. Or monument of title. Okay, so let's focus on that. First of all, the independent administration. So when someone has a will with independent administration, it names an independent executor or administrator. That's going to be usually in your line of work, that's going to be the person you're dealing with on the day-to-day basis, right? They're going to be the independent executor or administrator. They do have to be appointed by the court and take an oath. A notice to creditors has to go out. They do an inventory and appraisement. And then there's a little estate tax issue that can come into play. So back when I was an agent, I remember this was one of the things that we always wanted to know. Does the independent executor or administrator have the power to sell the real property? Okay. So you're dealing with this person who says they're the executor or the administrator, but are they the only one that has to sign? Right? That's something that you have to find out. Okay. And you have to find out from the person. And if you want to, you can always send us a copy of the will so we can look at it and help you determine that. Correct, Lisa, Sheila?
That is correct. We have new underwriting guidelines where it has to be within a year. So if someone's given power to sell, that's all good if they settle the estate within a year. Then after a year, then all heirs have to sign. And that will be your biggest argument and your biggest angry moment with your seller.
Can you repeat that one more time? I'm sorry.
If it's been over a year since they haven't completely closed the estate, then the underwriting guidelines for title company now makes all heirs sign instead of just the person that has power to sell. So a lot of times they get really upset about that issue. So,
yeah, because now they've got all these brothers and sisters that they always get along, right?
And they're all in different states, and it just becomes a longer process. We seem to be able to work through it, even though everybody gets angry.
Right. Yes, sir.
I'm in the middle of a intestate situation right now, and they told me that if I was an independent executor, I could do pretty much what I please, but as an administrator, I can only do what the court tells me through court decrees.
Okay. So that sounds like that's under I don't know if that's that slide. There was a slide for dependent administration.
Maybe that's where it is.
Yeah, it's not an independent administration, it's dependent administration, in which case the court makes the determination. Is that it?
Yeah.
Okay, all right, very good. So let me see what we have. All right. So I'm trying to, maybe a good takeaway for you when you go to list the property, if they say, and you're dealing with someone that has passed and there's a will and they're working on probate, that's one of the first things you need to determine. How old is that? You know, how long has it been in the process? Because like Lisa said, if it's been more than a year, everybody's got to sign. And also within that will, within the probate, who can sign? Can it just be the independent executor, or does it have to be everybody? Because that becomes really, really relevant. And you don't want to find that out when it comes to closing, because that happens sometimes. You get that one person to sign the listing agreement and the contract, then we get to closing, we're like, wait, everybody's got to sign, and y'all aren't real happy about that usually. Nobody's happy. So it's good to find that information out ahead of time. Anything to add? No? All right.
One thing I can add to that is sometimes I think we go ahead and take the contract with the person's power to sell signing the contract, and then if we determine that through the process, at closing, we get the other heirs to sign the contract for our records. So I don't know if you have to chase everybody down at the beginning of the contract.
Okay, that's a good point. And like Lisa said, we'll get it done. I mean, we deal with this stuff every day. You know, we get it done, but we have to end up finding the people, talk to them, explain to them. But yes, like she said, it doesn't necessarily mean you have to get them all at the beginning, but it's just good that they at least know that everybody's going to have to sign in the end. And we'll find them. We'll even track them down in prison or in Brazil. Barbara and I had one where there were heirs that were in Brazil, and we got that done too. That was a fun one, right? Okay, so intestate decedent. So when a person dies without a will, the title ends up passing to what's called the heirs at law. And how do we know who they are? Well, we know who they are through something called intestate succession. And in the state of Texas, there's very clear laws on the succession of who is entitled to the property. If there was that. So when someone dies without a will, there's a specific chain on who gets title and whether or not they're married. So first it goes to make sure I do this right, goes to the kids, right? If there are no children, then it would go to the parents, correct? And if there's no parents, then it would go to the siblings, right? So sometimes it literally it comes down to, you know, who's still living, did they have any heirs? But there's a real clear succession in when someone dies without a will. Anything?
How about that spouse?
Yeah, first it's a spouse, yes, but beyond the spouse, but that depends on if it's community or separate property.
And
that
if they
comes into
pass
play.
away past 93.
Sheila, let's hear it.
Well, the laws changed in 93, in 93, Lisa, in 1993. The laws changed before, if someone passed before 1993, then the succession was different than what it is now. The succession went half to the spouse and half to the children. Now, as long as they are married to each other and only had children with each other, then it goes to the spouse after 93. So that changed some. So it does depend on when, you know, the person passed away, because if it was before 93, then it's a whole different set of succession rules that we have to go by at that time. So
Where does it go if there's no siblings?
Okay, so I don't know.
after 93, it would go, well, first it goes to the spouse. If there's no spouse, then it would go to children. If there's no children, then it would go to the parents. If there's no parents, then it would go to siblings themselves.
And then if after
And if
siblings,
it's not siblings, it's cousins.
So at no point it ever goes to the state.
I guess unless they just had absolutely
If they
no
have
family
absolutely
whatsoever.
No heirs, then yeah, then we have to.
I was
Hopefully they have some cousins somewhere.
Right.
Everybody loves their cousins, so you better have.
Yeah, the cousins, they'll come bubbling up.
Oh, I have one thing to add to that though, like if it goes to the three, like two brothers and a sister, but one brother predeceased him, that doesn't mean it only goes to the other brother and sister. If that brother had children that are still alive,
It goes to the.
then you have the brother and sister, the deceased brother's children, and you may have 5. And I mean,
It can get very hairy.
Yeah.
Let's just
people
say
think
that.
if one predeceased and he doesn't count anymore, that's not true. The courts don't recognize
Where
that.
closing Abraham was 2 children for their parents. Then it closed and they got up and walked off because they didn't like their eight son, because they had been nice to them all that time. And they just walked away so nobody could give them money.
Wow.
It closed eventually, but it was,
Yeah.
they really made a point.
Yeah, yeah.
And then to add on to that, if they are married, half of it goes to the spouse. And if that person had children with someone else who wasn't their spouse, 50 goes to the spouse they're married to, and then 50 goes to the children they had prior.
Mm-hmm.
So it's kind of a tricky thing, and we have to figure out.
Right. That's horrible, because then mom doesn't let the spouse survive, maybe they need all that house.
That's what I know somebody is going
Hopefully
through that
they are
right now.
good to their
Their
stepchildren.
their stepkids are basically getting the house that she lives in, and they're telling her, "You gotta go, sorry."
And a lot
And
of
her
times,
husband just died 4 months ago, so.
and sometimes those stepkids don't have anything to do with that parent, weren't involved in
No,
their care.
not at all.
It's a sad situation, and we see it all.
But it's the law, and so we're sharing this with you so that when it comes up, you understand, we have to follow, obviously, whatever the law dictates, fair or not. Okay, so we got classification of property. You have community property, which is acquired during marriage, and separate property that's acquired before marriage or by gift or inheritance. Okay, so there's the 2 classifications. A couple of questions here, and this happens all the time. An owner gets married after taking ownership of the home, and the new spouse lives in the home. Okay, so somebody owns a house, they get married, and that spouse moves into the house with them. Does this spouse have to sign the closing documents?
Yes. But he got married after he signed, right?
But they share
That's right.
community property after that.
That's right.
But she doesn't sign it closing because he already owns it, right?
Yeah, but the new spouse still has to sign because
We're talking about resale now.
right. Yeah, now we're talking about resale. That's right. So they go to sell the house,
We've already moved in.
and since that person, and it's because of our community property laws in the state of Texas. Okay, and but sometimes you'll get I had an owner give a little pushback. He had a prenuptial agreement, and he thought that took care of his spouse not being his new spouse who moved into the home. He thought that took care of her not having to sign anything, the prenup.
Wow.
It didn't. It took care of a lot of other stuff, but the new spouse still had to come in and sign it. And he was not happy at all, but he had to do it. Anything to add?
The new spouse is actually there to convey her homesteader.
Yes. So by moving into the house, since Texas is a community property state, it automatically creates what's called a homestead interest in the property. And they have to sign that interest away. So they have to be on the deed. Should the new spouse have signed the listing agreement in the sales contract? So you go on a listing appointment and this person says, look, I bought the house before I was married. So I just have, and the woman has to sign everything. Should this new spouse sign the listing agreement in the sales contract? Okay, yeah. So our take on that is that, we're not involved in your contracts and we're not contract law professionals, but from a practical standpoint, it's a good idea to go ahead and have that new spouse involved from the beginning because they're going to have to be at the closing table anyway. So go ahead and get them to sign the listing agreement, sign off on the sales contracts too. Sheila, Lisa, agree? Okay, good. Glad y'all agree. Since I just said it. Yeah, you're right.
We're gonna say,
Yeah. No, Andy. Does that make sense, y'all? Yeah, okay. All right. So, intestate descent and distribution with community property. All right, with the surviving, okay, so there's a surviving spouse and there's no children, or their descendants, or all surviving children and descendants are also the children of the surviving spouse, everything goes to the surviving spouse. So you've got a couple, they were married when they bought the house. One of them dies, and either they have no children or all of the children are their children. All of that deceased spouse's interest goes to the surviving spouse.
After 1993.
After 1993, thank you. After 1993, that's right. Okay, makes sense? So everything goes to the surviving spouse. Kids are not involved at that time. All right, questions on that? Very good, all right. Intestate distribution community property with the surviving spouse and the children or their descendants who are also not children of the surviving spouse. So there's children involved from, let's say, a previous marriage, right? And like Cassidy said a minute ago, half of the community estate is retained by the surviving spouse. The other half passes to the children or the descendants in the same manner as separate property. So there's children from a prior marriage, they get half of it. Fair or not?
Okay, but what happens if he's, maybe I didn't understand this right.
Okay.
If the surviving spouse is still living there, the children couldn't sell it.
No, my understanding, no, correct? I mean, they can't kick the person out of the house, right? The children of the spouse that deceased from the previous marriage, they cannot make that person leave the house.
As long as they're, I'm asking that because I've had it happen to a friend of mine. Her mother had remarried after the children were all grown and had children. And they never could get that old man out of that house. He just kept there forever. It just went down, down, down.
Yeah.
That's because he has a homestead.
Yeah.
Yeah, so yeah, the law is there to protect them for that very situation. Now, when that person dies, those other kids will still get half of the interest, but not until the person dies or sells the house. Or sells the house. Okay, y'all got that? Okay. Okay, affidavit of heirship. So an affidavit of heirship, y'all actually have in front of you a copy of what's called an affidavit of heirship information form. And I'm going to need help how to get to that other attachment. Oh, look at those cute babies.
Thanks. Oh, wait, where'd they go?
She's like, let's just look at them.
Whose babies are those?
Those are mine.
Ah.
You didn't know that?
Yes. Oh boy. Hang on.
That's okay. We can just look at it.
It's because this was on full screen.
Oh, okay. So it's covering it up.
Yeah. There you go.
Okay. That'll work.
There you go.
All right. So how many of y'all have had to have one of these filled out before? The affidavit of heirship information form. Okay, you've had to? Okay. What this is for is when either someone dies without a will or they don't want to have the will probated. You can use an affidavit of heirship. The purpose of the affidavit of heirship is to determine who are the lawful heirs of the deceased. And there's some very specific information that has to be filled out. You know, the children, I need to put my glasses on here. So as you look at this form, what will happen is we will send you this form to give to the person that you're dealing with for the sale of the property, or we'll send it to them directly if y'all want us to. But we ask you, do you want to send it to them or do you want us to send it to them? And then we ask that they fill this form out. And so what it's got here is the first thing it asks is the name of the deceased, the property description, and then they ask for 2 affiants. Now this is an important part of this because 2 people without an interest in the sale of the property are going to have to sign off on this. That's what gives us the legal weight, right? 2 people are signing their name. Yes, these are the actual facts. So the person is going to have to, the person selling the property is going to have to identify 2 disinterested parties to sign off on this. Now, it can be a family member, as long as that family member does not have any interest in the sale of the property. Okay, so it can be a sibling that's not going to get any interest, or a cousin, or whatever the case may be. If they're not going to, if they don't have any legal interest in the property, they can be one of the affiants. So that's one of the things they're going to have to determine. Of course, they need the birth date, the death date, where they died, their residence, and then their marital history. Beyond the marital history, they need to know the names of all the children, when those children were born, if any of the children died, if the decedent was not survived by any descendants, then we need to know their mother's name and father's name. And if they were not survived by any descendants or the mother and father, then we need to know the sibling's name. Just like we said earlier, it's it's children, parents, and then siblings. So all this information has to be filled out, and sometimes it ends up we have to add pages have to be added to this because there's a lot of information involved. So once this information sheet is filled out, we then send it to our attorney to draft the actual affidavit of heirship. And sometimes the attorney comes back and says, look, we need more information. How long did this affiant know the deceased, or how long was the relationship? Because if one of the affiants did not know the family for very long, they may not be allowed to be an affiant, right? Yep. Anything to add? Yeah. I'm just going to keep talking.
Keep going. I'll stop you.
Yeah, you will. So we send it to our attorneys. The attorneys often come back and say, we need a little bit more information. So we go back to you, or we go back to the person that filled it out, says we need some more information. So sometimes it can get fairly complicated going back and forth. Barbara, the one you and I had, whew, it was very, very complicated, but we finally got it, because two of the children from a previous marriage were in Brazil, and yada yada. Anyway, but we finally got it taken care of. So then the attorney drafts the affidavit of heirship. We then have to have those 2 affiants sign it and have it notarized. And we can FedEx it to them, and they can notarize and send it back to us, however we have to handle it. But those 2 affiants are going to have to sign it, have it notarized, and then it needs a 3rd signature. Anybody know what the 3rd signature is? Bonus question. Anyone? Pardon me? She said, the 3rd signature has to be a corroborating heir. So if you, on the affidavit of heirship, it'll have a place for the 2 affiants to sign, and then a corroborating heir, someone who does have an interest in the property, needs to sign off on this too. Normally we get the corroborating heir to sign it at closing. Whoever's signing there at closing, they're obviously going to be one of the heirs, and they can sign off on it at that time. All right. Then what we do is this then takes the place of basically the probated will. All right, this is a legal document that establishes, okay, here are all the heirs to the property. Now, once all the heirs are determined, are all those heirs going to have to sign at closing? Yes. Yeah, they are going to have to sign at closing. Okay. So, Barbara, I'm going to keep using this example because it's still very fresh on my mind. Very fresh on my mind. 2 of the heirs were in Brazil, okay, and the other heir lived here. Well, they ended up giving power of attorney to the person who lived here in the States, and that person signed on their behalf. So, but all the heirs, as determined by the affidavit of heirship, are going to have to sign at closing or give power of attorney to someone to sign for them. Anything, Lisa?
No.
How do you get power of attorney for people living out of the country?
It was not fun, but we did it. So,
Do you want me to switch back?
yes, please. And I'm glad you brought that up, because the power of attorney has to be approved by our underwriting department. So I had to have them, we communicated via email. They sent me a copy of the power of attorney they were planning on signing. I sent it to our examination department, and they approved it and agreed, okay, this power of attorney is acceptable. And then we had them execute it. And that, just a little side point here, We see some crazy powers of attorney that are like in no way going to be valid. You know, people end up finding things online or something. So anyone that's using a power of attorney to sign, let us look at it first. Okay, and if you need one, we can provide you a blank one to use. All right.
And speaking of power of attorneys, whenever someone is assigned as the independent executor of an estate, they cannot be signed as a power of attorney, cannot be signed for them. So in other words, they have to actually come to closing to sign. They can't have someone sign power of attorney for them. So just to let you know that.
Okay. Any questions yet? Okay. Seems like we got to add more on that affidavit of heirship. I know there's more that happens. But...
The only thing that I would add is sometimes we do a title search on property that has been sold forever and no one ever had title insurance. It's a long chain of title, and you have to go back to somebody maybe that was born in 1912, and they were married to this person and passed away. So then they'll say, well, the only one that knew him was the little 22-year-old neighbor that knew him for the last 2 years. Well, that 22-year-old neighbor can't say that they knew them, and maybe they were born in 1912, they got married in 1940. You know, there's no way that person would know that history on them. So even though they knew, I mean, it's a sworn affidavit they're signing to test to this deceased person's fact. This is when they were born, this is who they were married to, then they married this person, the first wife they had these kids, the second wife they had these kids. There really needs to be someone that has a history with them, not someone that just knew them the last 2 years. And the attorney sometimes will kick it back when you send it, and they'll say, well, does this person really know these facts? And so
Can it be a distant relative?
it can be, and it can be a brother-in-law, a sister-in-law, you know, somebody, as long as the person doesn't have any capital gain out of the sale.
And underlying all of this is, you know, we issue a title insurance policy on the property after it closes. So after it closes, we're on the hook for whatever happens, right? So some long lost heir pops up and says, wait a second, you know, I have an interest in that property too. Well, that ends up becoming a claim for the title insurance company that we have to remedy. So that's why, you know, when Lisa mentioned that, we want to make sure that the person or our underwriters want to make sure that the person signing off, that the affiant really knows the facts. And there wasn't some other marriage at some point in time and other children out there, because it can happen. They come popping up out of the woodworks, right?
Yeah, we have a lot of people saying, well, we have a brother, but nobody's talked to him in 40 years. And we don't even know where he lives. We don't have an address. But his interest just doesn't go away because of that. They have to find him.
He will show up sooner or later. All right, so some best practices for you here. First of all, for you, best practices. Is the owner deceased? If so, ask for a copy of a death certificate from them. Do they have a will? Will they probate the will? How long ago did they die? Where are they in the probate process? Gather this information when you're on your listing appointment, and if you have questions, call your escrow officer and talk to us about it. You know, it makes much more sense to cover those issues in the beginning before you put that property on the market, because you don't want it to become an issue. You get it under, you do all that work, get it under contract, and then we have a problem on down the road. So, you know, that's what we're here for, to answer your questions for you. If there is no will or no probate, get the AOH, as the affidavit of heirship information form, completed at that time, right? You've got a copy of it there. We can send you a digital copy of it too. Go ahead and get them to fill it out at that time. You know, it just saves time on down the road. Okay, any questions on that?
One thing on that, Andy, just emphasize what he's saying. When he talked about, we were ready to close about 2 weeks out from the balance problem. Listing agent had no idea.
Because that's when we got the title commitment. We got the title commitment back. And we don't know until,
That's when the buyer we closed for 6 months.
yeah, 6 months. This is Jefferson County. Yeah. Yep. All right. A real quick note, and we're going to move on to a couple of Schedule A and C scenarios, but this was included in the materials, something called a transfer on death deed. And just some background information for you. There's something known as a TOD deed, T-O-D-D, where a property owner can designate a beneficiary to receive the property automatically upon their death. It bypasses all this stuff, right? It's called a TOD deed, transfer on death deed. So the TOD deed says that it basically says, when I die, here's where I want my interest to go to. It's already in that deed. And so when our title examination department finds that deed, that's the person who's going to automatically be entitled. You know, if they passed away, that's the person that's automatically entitled. So it can save a lot of headache with probate and all these other things we're talking about.
It has to be recorded before the person dies.
Right. That's a good point.
And it can be, it has to go in the order of benefit, it can be anybody.
As far as I know, it can be anyone, right? Yeah. So that's a very handy legal instrument that a lot of people don't know about, especially if they're not working with an attorney. A good probate attorney or a good attorney will let them know about that, but a lot of people don't know about that. It is. It's a lot cheaper. But it does have to be recorded, just as she said, because otherwise it, you know, we don't know if that person really wanted that or not, because it never was recorded. So yeah, it does have to be recorded. Plus our examination department won't find it unless it was recorded.
Right, and in that deed as well, the reason it can be recorded, because in that deed, it also lets the person who owns the property retain a life estate interest into the property. So it's not like that person can come in and say, well, since you gave me the deed, then, you know, you got to get out. No, they are there until they pass away. So that's why also, you know, it's retained in that deed as well.
But that saves them from the half is mine situation, right?
Mm-hmm. The owner retains, this is still on the TOD deed, the owner retains full authority to transfer or encumber the property till death. A TOD is revocable during the lifetime of the transferor, but cannot be revoked by a will. And a TOD cannot be created through the use of a power of attorney. So if they give someone power of attorney, that person cannot go create that on their behalf. That would be a little shady, right?
It'd be a lot shady.
A lot shady. Okay, any questions on any of that? Cassidy, anything to add?
I do have a question about that.
Uh-huh.
And y'all say it on this one. What happens if they don't want to deed that to that person anymore? If they want to say, oh, well, I don't know,
They can revoke it. Yeah, so it's revocable during their lifetime. As long as they're still living, they can revoke it. They can take it back.
Okay.
It's good. No, it's a good question, because that might not have been clear.
I mean, maybe probably everybody else.
All right, so let's go. We got a couple of case studies here, if you will, and I need to get to those on here. All right. So if you look in your final handout, if anybody have any lingering questions, burning issues right now? Did you get this? So there's actually these are two different scenarios. I've stapled them both together. You've got the first page is Schedule A, second page is Schedule C. That's one scenario. The third page is Schedule C. That starts the second scenario. All right, so this is actually two different issues. I don't know what we're going to be talking about here. And this is one that I'm actually closing today. All right, good. I need my eyes here. All right, so we got the title commitment back on this one, and everybody here reads their title commitments, right?
Oh, yeah.
Barbara says no. All right. Well, I would recommend that you read your title commitment, because this scenario right here, we got the title commitment back, and it says that the record owner, the record title is in Terrence Bello and Judith Dish Jasper. Guess what my contract said? Gary Jasper and Judith Dish Jasper. So I get this contract. It's got Gary Jasper and Judith Jasper, Who's this Terrence Bello fellow, right? Who is this? So that was the first red flag. We then go to Schedule C, which is the next page.
But our good closers always call that our kids.
That is right.
So we don't have to read all this.
We recommend you read it still.
We
Please.
know you'll tell us.
But we know.
That's when we email you, say,
Hey, hey,
hey.
we got some stuff going on here. All right, so if you go all the way down to number 8 on that Schedule C, that's where it discusses where this Terrence Bello came from. And I'll summarize it for you here. What happened was Terrence Bello was Judith Jasper's son. Okay? They took title, but they bought the property together. He passed away. Complicating matters a little bit. The father, Judith's ex-husband, his name was Terrence Bello also. So this gets a little bit confusing. So they're both Terrence Bello. What they tried to do was use a quitclaim deed to deed his interest from a trust over to Judith Jasper. Long story short, that the way they did it wasn't valid, and so we basically had to ignore that quitclaim deed. They tried to do what was right. They tried to get his interest just over to the mother since he was passed away, so it would just be in her name, but they didn't do it the right way. Does that happen? All the time.
get all that out of that?
And an email from us or a phone call, yes. Yeah.
Well,
Yeah,
a side note also about quitclaim deeds before you jump off in that, quitclaim deeds are not worth the paper they're written on, honestly. We do not insure on quitclaim deeds, so even if there is one of record, 9 times out of 10, we're gonna have a special warranty deed or a warranty deed prepared to take the place of that quitclaim deed. So just to let you know. If you hear someone talk about quitclaim deeds, just go, ugh, that's what we do. We shudder at that point. But go ahead.
quitclaim deeds, that's good. Thank you for bringing that up. All right, so that quitclaim deed was not recognized. So now, since he has passed away, the interest then goes to, so then what we had to do, be back up just a minute. They did the title search. They see there's this Gary Jasper and Judith Jasper. Gary is Judith's new husband. And they even made a little note about that. Well, it's here at the bottom, the examiner's note. Title is shown on Schedule A above, but according to the order, the contract, it's showing Gary Jasper and Judith Jasper. So as far as we're concerned, title is still held in this deceased son's name. So what do? Well, we had to get an affidavit of heirship for him, right? So we can determine his line of succession. He didn't have any children. He never married, didn't have any children. So it made it fairly simple, but we still had to have an affidavit of heirship done. And so we found 2 affiants. One was in Colorado, one was in California. So I sent them got the affidavit of heirship done, had them sign it, and now we're going to have Judith sign it at closing. So what that does is it establishes his line of heirs. Since he didn't have any children, where does his interest go to? Y'all remember the line of succession?
His dad, the parent.
The parent. The ex-husband, Terrence Sr.
Oh.
Right.
Terrence.
Terrence.
Love to see the new
Yes.
one.
Fortunately, so I called Terrence. I said, hello, here's what we got going on. And fortunately, everything was amicable. And basically I said, look, we see where you tried to get your son's interest, because he was involved in trying to get his son's interest over to his ex-wife. So he was playing ball, right? I said, we see where you tried to do this, but we don't recognize that quitclaim deed. We're going to have you deed your interest over to your son. Are you willing to do that? He said, yes. I'm
To
like,
your ex.
excuse me, your ex-wife. Thank you. Yeah, to your ex-wife. Are you willing to do that? And fortunately, he said yes. So we got our attorney to not only do the affidavit of heirship, we had him actually go ahead and do a deed from Terrence Bello Sr. to Judith Jasper, so that all of that son's interest that went to the ex-husband now goes over to Judith Jasper. Now, we go to closing. Judith is the only one that has to sign the closing documents, right? What about Gary Jasper, her new husband? Remember that? Remember him? So I had to ask. No, fortunately, he's still living. We're okay there. So I had to ask, did Gary ever live in the home? No, he never lived in the house. So that makes things a little bit simpler. All we have to do is have him sign what's called a non-homestead affidavit. And he's saying, I have no community interest, interest in the property. I never lived there, yada, 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 and we're good with that. So actually, as soon as we get back to the office, that's the package we're mailing to Judy Jasper. This is such fresh information. It's happening like right now. So on the very top, I put Gary's document that he has to sign and have notarized, and she signs everything else, and then we're done. So that's a nice. What's that?
She said you get so excited, it's so fresh.
I know, it is.
A few years you'll be like, oh.
I know. I still think all this stuff's very interesting. They're like, yeah.
But he was talking about going to policy the other day. I had to stop him.
Wait, go where?
Policy, whenever you're like, I need to go to the policy department.
Yeah, right. This is interesting. Yeah.
Then Terrence, how did he just transferred his interest to the
Yes.
HOA?
So we.
And he does not. So now he does not have any claim.
That's right.
Any, anything, any funds.
That's right. He's out of it. So the affidavit of heirship established that the deceased person's interest in the property went to Terrence Sr., and then that deed takes Terrence Sr.'s interest and gives it to Judy. So we have to file the affidavit of heirship first. And all this happens at one time at closing. We file the affidavit of heirship first. Then we record that deed from Terrence to Judy. Then we record the deed from Judy to the new buyer. It all happens at.
But what if it says, I need part of the funds that are coming in,
They got to work it out. They have to work it out.
He could be a payoff person as well.
Yeah, that's.
So
It could be a thing, yes.
he very much could. We would need like an invoice or something stating, hey, I am owed this money in order for this deed to be recorded in record, and we would pay him at closing as well.
Got
it.
There you go. Yep. Okay.
He's just being nice.
He's being very nice. Okay. Any other questions on that one? Okay. No? Y'all good back there?
I am going through something just a little bit. Seller was killed, and I have two boys, two heirs. One's taking the bull by the horns and going. He got interstate, so he's taking the bull by the horns, going in front of a Colorado and California judge. This month, he owned multiple houses. So as soon as that is over, then it's coming to here, and then we should be able to sell it, right? Or are you saying that I could take something like this and get it going right here?
Anyone? Anyone? I got it.
He already have an administration.
He's going in front of two judges this November.
But not in Texas.
No, he has to come down though. It's following suit, but he has to go to California. And Homestead was in California. He had another house in California, Colorado, and I think he has somewhere out of the country, but he has one here. So as soon as that gets done, then it's going to trickle down here. So, but if I did this, could this bypass any of that?
Possibly so.
You think?
He didn't have a will.
No, it just is the only one I care about is this state. This is the only one I care about. Yeah, if his brother would sign off on that.
Did he have a
It's only
will?
2 boys. Only 2 brothers. So. See it.
Okay, so there are 2 brothers that are the children of the deceased, right?
Uh-huh. Mm-hmm.
Okay, the property's here in this area,
Yes.
right? Okay. Yes, I don't know why that.
No will. He got
No will.
Yeah, so that could be used to establish. Now they're going to need 2 affiants, of course, like we talked about. Yeah. Did the deceased was he any prior marriages with any other children?
No, he only has 2 kids and both of them.
Both of them were different moms?
Yeah.
Okay, well, that's not necessarily.
Agree.
Yeah,
Yeah.
and they're both alive. So they're stepbrothers. Half brothers. Oh, half brothers. Gotcha. Half brothers. Okay. All right.
Yeah, as long as they agree, and then at the end, because I'm sure there's gonna be some money played into that, we would have to know by them in writing who receives what from the sale of the property.
Yeah, and there's a form that we use at closing. Y'all may have seen. It's called a distribution of proceeds form, and it may be good to go ahead and have them look at that and sign off on that before they come to closing.
Okay, maybe I can get that from you.
Yeah, who's going to get how much? Yeah,
Or,
right.
or an email, from each party stating this is what needs to be done, but they're gonna sign that form, that distribution form at closing as well. So,
Yeah.
But we'd like to know that in case we need to put it on the settlement statement so everybody can see and it'd be clear, because if we don't know until that time, we won't be able to put it on.
It's a big house.
Yeah.
Thank you so much.
Okay. All right, you're welcome. All right, we did have one more scenario, but we're almost out of time here. Can we just, Sheila, you want to talk about that one real quick? You want to open up for
No,
questions?
that was just, that's actually right there, the one on the last one is just showing you
Keep lifting
that
the
there
third page.
was some errors. There is no affidavit of heirship for probate. So that is what it looks like when we're asking, well, hey, we know this person is deceased. Is there a probate maybe filed in another county, or are we gonna have to get heirship affidavit? If there is a probate filed in another county, it does list on the last page what we need in order for us to be able to look at that, and we will have to have that filed in the county that the property is in as well. We will have to have the will, the application, the order, the oath, the inventory, and the evidence. And one side note on that inventory, a lot of times the inventory, if there's a probated will, the inventory is not usually ready. We usually can take a letter from the attorney stating that the will does not have enough, lose my words.
The
It's not
state doesn't warrant.
warrant. Yes, there you go. The
Like
state's
$3
not
million or
warranted.
something like that?
Uh,
It's a big figure.
Yeah, it's like 3 or 4 now. It was 2, and then they moved it up. I think was it 4 now? I think so, something like that, or above. Yeah, it's so. But a letter from the attorney, either by email as well as if they have their information on there as well, usually will suffice stating that, so we can put that in our file in order to keep moving on for closing. Because a lot of times that is the very last thing done in a probate, and so we don't have to wait on that as long as we have that letter.
Good synopsis. Okay, we're going to open the floor for questions now. We all know if you do have questions, contact one of your friendly escrow officers at Stewart Title. We are here to help. Or our assistants. You know, Cassidy is my assistant. Lisa has assistants. Sheila has assistants. And a lot of time it's the assistants that are involved in the nuts and bolts of getting some of this stuff done. So certainly contact us or our assistants. That's what we're there to help you with if you have questions. All right. And thank y'all for coming.
Thank you.
And we'll see you. And we'll see you at Stewart Title.
Thanks, Andy.